Hi, my name is Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan. And today we're going to continue our video series designed to educate and inform the public, so please subscribe to our channel. Today I'd like to talk about a very interesting topic. It's a very hot topic. It's the interplay between settling a divorce case through normal process, trial process, versus a mediation process. What are the pros and cons of going to a mediation process? Well, first, by definition, a mediation process means the court or the parties on their own will agree to appoint a mediator whose job it will be to try and bridge the gap between the prospective issues that there are and the positions that the parties take in those issues. It could be an issue about custody or some sort of support or property division or any at all issues that come up in a divorce case. You always have a choice. You can go to trial. And if you go to trial, the judge will make that decision. It won't be a compromised decision. It'll be based on the hearing of the evidence, and the court will give its decision. You may win in that process. You may lose in that process. Because it's more definitive, the trial will come as a result of the bringing of proofs. Certain evidence has to be gathered. That has to be done in a certain way. Trials, because of the preparation involved, tend to be very, very expensive. A mediation process is a little more flexible. It doesn't necessarily require the same level of proof, which the court will require. There is a level of preparation, but it's not the same as the level that you prepare for a trial. So the costs of a mediation process are considerably less than taking something to trial. Some people, though, feel that they need to be heard. They need the court to hear them out on whatever their grievance is. If that's the case, you don't get that in a mediation, so you're denied that. Maybe that's a con. On the other hand, maybe it's best that the parties air their grievances to friends and family rather than spend the money to do that in front of a judge. So there's what to be said for that too. I will tell you that I think the mediation process has tremendous advantage. It saves the parties a lot of money. It gives both parties an opportunity to control their own destiny. When you're in court, you don't control your own destiny. The court does. In the mediation process, you still have a right to say, yes, I'll agree to this, or no, I won't. You lose that right when you put everything in front of the judge. You're basically agreeing to abide by his or her decision. That level of autonomy that you relinquish in the trial is somewhat of a con in the pros and cons of trial versus mediation. Every case is different. Some cases lend themselves to trial. Some don't. Some lend themselves to mediation. In a situation, for example, where there may be a fault factor, where a judge may change the property settlement because someone has done something wrong that proximately caused the breakdown of an otherwise good relationship in the marriage, something that the court can take into account. Mediation may take it into account to some degree, but probably not. So these are amongst the pros and cons. If you have any questions about your case, of course, reach out and we'll be glad to help you out.